Qiuyi, how are you?
Good, how are you,
A
Andrew?
surprise guest.
Surprise, surprise, first time.
Yeah, no, Kim got scratched on. She's sick as a dog, so she's at home, and Qiuyi, without knowing about it, was dragged into the room. So he'll be a bit quieter than most today, and he doesn't swear like Kim, so it's pretty straightforward.
Yeah, thank you. Thank you. I'll try. I'm not I'm not used to camera.
No, that's
But
okay. Well, no, you can be more conservative. You'll learn it. Now, one of the things we're going to talk about today, and our major topic is what happens when people leave work, they ingest alcohol or drugs, and they then arrive at work in a state that affects their judgment or capacity. That's our major topic for today. But I want you to remember this is an issue that affects every single organisation, and how you manage and plan this is a very big issue. So we're going to spend about 10 minutes on that. But I think we'll jump straight into our first case, which is Dr. Ferruri's case.
yes.
Interesting case, isn't it, really? This is a $230 million settled class action. They're just waiting for a sign-off by the New South Wales Supreme Court.
Yeah.
And it's for 20,000 doctors since 2014 for underpayments.
Yeah. I think that's probably the biggest settlement now.
It is the biggest class action settlement of this kind, but this is an industry where historically young doctors are expected to work ridiculous hours, where the evidence from the College of Surgeons is it creates enormous patient risk as well.
Yeah.
And what nobody did was actually work out, well, what are the hours, what are the overtime? They're all captured by enterprise agreement. So there were discernible methods that could have been added to it. But there was an expectation, because of the nature of the culture of medicine, that this was part of what being a doctor is about, is working these chaotic and long hours.
Yeah, exactly. And I recall reading some news back in, I think, 2023, they talk about, some of the doctors even forgot whether they went to toilet or not.
Yeah.
Well, during the days.
Yeah. So, and I guess for us, well, does it matter as a case? Well, yeah, it really does matter as a case, because there are a whole group of muscular professions in the white collar industry which were dominated by men and male behaviour.
Yeah.
Like us, and Qiuyi and I are both men, but that's not deliberate for the day, I might add. But where the expectation of work has always been extreme, where there has always been this expectation, almost a pride in working at long hours. In fact, when I first started law, you didn't leave till the partner left. So there'd be 6 of us in the office watching the partner at the door, and when he left, and there was always he's, we'd go and have a drink. But it'd often be 10:30 at night, and it'd be 4 nights a week, and we'd have nothing to do. We'd just be sitting there, just waiting for the partner to leave, because part of being macho, tough lawyer was, you said, yeah, I got here at 7 and I left at 10. And we go down to Jackson's Bar, this was in Launceston, and we'd all go there and go, they go, oh, the lawyers are here. We go, yeah, hard night. Wow. Okay. So it's not just law, it's engineering, it's accounting. There's a whole lot of professions where their expectation of high workload is normal. But what we found when we set up our law firm is that once you push people past a particular period of time, the quality of work just drops off. Right. So we made a deliberate idea of, when we allocated work, to set expectations where people were providing their best work, not just putting their head down and working until they fell on the ground. What this shows is, in all those professions, and in the more blue-collar ones like plumbing and other areas where they're inclined to be dominated by a family who works really, really hard, there is this huge risk that sits around underpayment. So I thought it was there's nothing magical about the case, it's a huge award, but it does shine a light on that entrepreneurial behaviour that leads to risk now.
Exactly.
Let's go on to Page's case, which is a sort of fascinating safety case that just came out, Qiuyi. This is a case of an individual who was charged under a personal duty in respect of a crane that was moving heavy steel. Anybody who knows safety knows that when you have cranes operating in a space where they're carrying high loads which are at a low level, in other words, they can hit people, you need physical separation from pedestrians. So it is about barricading an area to make it safe. In this case, the guy involved, instead of doing what he knew he had to do, because that was the requirement, he gave verbal directions, and he ended up being fined. Now, what's important about this case is not that an individual who was supposed to put in safety measures has been fined, who wasn't an officer of a business, just a supervisor, and it was under his personal duty, so it was a very low level. He could have only been fined $176,000. What's really interesting is, you remember in all safety, you start off at the bottom end. Courts start an argument or a narrative around risk and liability, and then they push it bit by bit up the hill. And so the regulators follow where the courts go.
Yeah.
So he only got fined $6,000 after the discount for an early plea plus $10,000 costs. What he did was terrible. Okay.
Yeah.
3 years ago, he wouldn't have been prosecuted.
Yeah.
But today he is, and he was prosecuted by Justice Scotting, who is an ex-prosecutor, who has gone out of his way to set up this narrative around individual responsibility, which has been, in the New South Wales jurisdiction, a major issue back to when they had their reverse onus and individual liability was pursued for a period of time there. So what is the trend that's coming out of this case? Individual liability.
Right.
And it means that not only will there be more individuals charged for their personal duty, we'll start to see reckless endangerment, because this is a case really which in 3 years' time will be a reckless endangerment charge.
Sure. So you do think that this case actually precedent sort of suggests a trend?
It's the beginning of a narrative.
Yeah.
And one of the things that's we know in safety law is you start seeing regulators making charges, they get battered back, doesn't succeed, then suddenly a judge takes it. Scotting is the most aggressive judge in that jurisdiction in picking that narrative and running with it. And as a result of that, not so much a precedent, but it is a trend. The other trend we're seeing in New South Wales and Victoria is individual liability for major wrongs is going to reckless endangerment. So, I think it's a pivot point.
Sure. Okay.
All right. Well, let's move on to our next case. And I think this is Muthu Oosting, and for that person, I hope I spelled it right, said it right. I'm not sure. This is a return to work case, and probably in the cases we deal with today, one of the most illuminating cases around risk that we see. This is a person who suffered an injury, went on workers' compensation, and then refused to vaccinate during the mandatory vaccination requirements of government. And the South Australian workers' comp regulator said, well, it's no longer an issue of capacity because you've taken the question of capacity away. You're now unable to work through a decision you made.
Yeah.
So pretty important. Remember, workers' compensation only focuses on capacity. So we don't look at who you are, what colour you are, what age you are. We go directly to, do you have capacity to work? In respect of that capacity, what is the obligation and potential to return you to work?
Yeah.
But if you do something that prevents you from returning to work, you breach your obligation to assist in the return to work.
Sure.
So do you see any other issues where that could go more broadly, Qiuyi? So forget about vaccination cases.
Yeah. How about, like a solicitor forgot to renew their practice certificate?
Totally. Yeah. If we look at in nearly all the financial services industries, there is accreditations and requirements to be registered or to be to hold certification.
Yeah.
So if you let those lapse, there is a very strong argument to say, well, now it's not a question of capacity. You've chosen not to do that.
Sure.
At the moment, we can't return you to work because even if you did have capacity, you breached your return to work obligations.
Yeah, sure.
So in this case, South Australia is a slightly more onerous jurisdiction than other jurisdictions for employees in this respect. In Victoria, this would be a conversation to have with the insurance, say, well, this person, whether they have capacity or not, has chosen to take action or omitted to take action that allows them to return to work. Why should we be liable?
Right.
So in our workers' compensation masterclass yesterday, we had two people who were there who raised just this question. This is the case that answers that.
Okay.
All right, let's keep rolling.
Keep rolling.
I think we are on to Manker and Tees.
Yes.
Tell me a bit about the facts in this case.
Oh, this case, another crane accident.
Yep. I think in this case, not a crane accident. I think this was a slip case, wasn't it?
Yeah, it is.
Yeah.
Sorry.
I snuck that one in. I didn't warn you I was going to do that. So this was a slip case in an abattoir. Tees is one of the largest abattoirs. And the guy had his workers' compensation, went on to make a common law claim and said that there'd been no proper educational training around how to keep his hands clear as he was climbing upstairs, where a handrail was there. Had he have known that, he would have held onto the handrail and he wouldn't have fallen over. I think after the judge stopped rolling on the ground laughing, he said, no damage to you, mate, on the basis that, well, no, there was a handrail, there was policies that said that's what to happen, and there's evidence that they were trained in it. So the case is an interesting case for this reason. What it says in relation to common law is, yes, it is reasonably foreseeable you will slip and fall in an abattoir, but it is not reasonably foreseeable you will slip and fall where the circumstances that would prevent that fall are well known to you, where you've been educated on, and they are available. And after that, it's your problem. So that's what it means for common law.
Yeah, sure. Well, do you think there's parallel obligations in other like safety laws?
Yeah, there is. I think in safety law, what this says is the same thing. You can imagine a regulator coming in, they do their investigation, and they go, okay, person been injured in inherently dangerous area, slippage on the floor because of blood and meat products that are on the floor. How is this managed? Well, you do have a system of work. Okay, so have you identified the hazard? Let's talk about reasonable practicability. Have I identified the hazard? Yes, slippage on the floor. What's the level of risk? Well, it's medium to high because there's a level of frequency, but the likelihood of serious injury is relatively low. What's the control in place? Well, you've got a handrail, you've got policies, you've got education. So on the hierarchy of control, you've met the mechanical control, you've met the administrative controls. Actually, they're good controls and they're adequately resourced. So you've done everything that's reasonably practical. Then look at the duties to provide a safe workplace. Yes. To have a proper system of work. Yes. Supervision. Yes. Education. Yes. Okay, so there's no primary duty breach.
Right.
So although the case is about the common law, it is illustrative of where it would also land in a safety jurisdiction. A regulator would never bring this as a claim. It's sort of one of the, every now and again at common law, for whatever the reason is, and I don't know it, and maybe it's the nature of common law plaintiff lawyers who run stuff without much sophistication. There are cases which anyone who reflected on it would go, I don't think I should run this. I think someone will laugh at me if I run this. And this is one of those cases when I read it, I thought,
Right.
You know, a bit of the Jimmy Connors. You can't be serious. You know,
Yeah,
it wasn't
sure.
Jimmy Connors, was it? It was, I forgot who the other guy was. Anyway, whatever it was, this was an odd case to run. So I think it's probably time where we jump into the main topic. I'm not sure about that, but I reckon it probably is. So Sophie, you're there for me? Can you change me? Tara? Yeah, it is the main topic. So what we're going to talk about today is drinking. And part of the reason we're going to talk about it is a constant theme, whether you're in professional services, white collar or blue collar, you're going to have these circumstances where people drink alcohol, where people use drugs, and then they attend work. And what Qiuyi and I really want to talk about is, where do the legal obligations start and finish? When people do stuff that's outside of work, does that create a liability? We'll talk about that. But the key part about today is talking about what happens when you come back to work and you are affected. So if we can go on to the next case, that'd be really good. So we're going to talk about Johnson's case. Not really that difficult. This is a case where a guy got told he was going to be called in early the next day. He consumed between 12 to 15 beers, which is a good night's work.
Yeah.
Came to work, told to come back later in the day because they thought he was affected by alcohol. There was a policy that exists around alcohol, but the process of determining whether he was so affected by alcohol as to render his conduct serious misconduct was really mishandled. So to explain that, we haven't got clarity in testing in your policy and procedure, and we'll talk about that more in a second. You're left then with the definition of serious misconduct, which turns up in Regulation 107 of the Fair Work Regulations.
Yeah.
And it talks about being under the influence of drugs or alcohol. So you must have evidence, not only that a person has drank, but that the amount that they've drunk has made them so affected by work, that alcohol, that it affects their judgment and capacity to work. That's the test, okay?
Yeah.
Now, we see that, and all of us know you can smell alcohol on a person. So if a person's unsteady on their feet, they're slurring, they're showing poor judgment, they're bleary-eyed, they're all objective evidence of being intoxicated.
Yeah.
But do you want to run a case based on that? So the answer is, if it's dangerous and you feel it's unsafe and you've got those observations, they are objective evidence of being under the influence, but you'd want to document them. Okay, you notice they stumbled and tripped, you notice this. You actually test it for yourself the best you can. It's a bit like the old Texas 0.5 thing where people had to walk along a line. You've got to actually be satisfied that all the physical indicators of being intoxicated were present before you send the person home. Then when you send them home, you've got to send them home in a taxi and make sure they're safe on the way home, direct them to come back at a later time.
Sure. So, Andrew, do you think that in terms of testing, and observation is sufficient, or you really need such, meters in terms of the alcohol percentage?
Yeah, I think that your drug and alcohol policy should have testing as where there is a reasonable basis for testing. You should be able to do it.
Should be able to do it.
Yeah. We've never had them in law firms, I might add, but majority of my clients would have drug and alcohol testing as part of a regime.
Yeah.
But it must be on a reasonable basis, and the reasonable basis is slurring, bleary-eyed, incoherent speech, that type of stuff.
Yeah.
It's just a fantastic measure. If the person doesn't then comply with the testing, it's a bit like failing to undertake a test by a policeman. At that stage, it's a much more serious offence. It's failure to comply with a lawful and reasonable direction, and that it was also under Regulation 107 as serious misconduct. If that had have happened here and testing had have happened here, this person wouldn't have won the case. Now, this person won the case, except obviously being intoxicated. But even the Commissioner Crawford, only awarded $5,400. So it was a bit of, look, you failed on the fairness part. You're probably right. It was a valid reason, but it's a small penalty that's being paid.
Right. So what if, you probably came across this before, what if the employee says, well, you saw me driving to work. You said that I'm intoxicated. You now want to test me. I don't want to be tested. How can I trust you that you don't give the record to police, which will incriminate me?
Yeah, well, there you go. The incriminate's the final word, really, isn't it? The short answer is, if you're so worried you're going to get in trouble with the police, you've got a lot to worry about. The only question that arises is, are you safe to be at work?
Yeah.
So I want you to, that's part of what we're talking about today, is focus on safety.
Yeah.
And if your concern is the person is not safe to undertake the inherent requirements of the job, you must intervene.
Sure.
And it doesn't matter what they say about the records or anything. They just say, no, you've attended work. I have a reasonable basis for believing you're not fit for work as a result of drinking. I can't let you be at work. I'm directing you to go home. I don't want you to drive. I'm quite happy to take your car keys and organise for a taxi to do that. Yeah. And if they drive and say, no, I'm driving, say, well, I understand that's foolish given my observations, but you can't obviously wrestle the person to the ground.
Sure.
Okay. I think probably then let's have a look at, I think the one that we're going to talk about is Keenan. Keenan is a case, it's an older case of a guy who worked for Leighton who came to a party put on by Leighton, which went for 4 hours, where there's an open bar. He drank a lot, he behaved badly, and after the event he went upstairs, he sexually harassed the HR manager.
Yeah.
If you're ever going to do something stupid, that would be it, wouldn't it? Sexually harassing an HR manager. And when it got to the commission, what the commission said is, well, look, you condoned the behaviour. You actually had an open bar. So you can't criticise drinking as a behaviour and the behaviours that come from it, when what you did was allow the person to get inebriated in the first place.
Yeah.
So that's a good question, isn't it? Because it arises not only through work functions, but through sales meetings at lunchtimes or after drink get-together by people. If we allow people to feel or know it is condoned to have drinking sessions, and where we know that that drinking session could have an impact on other people's safety, it's very hard for us to punish, because we can't punish that which we permit. That's the law of condonation. So Keenan's more about condonation. It's not a great case, and I don't think it's necessarily well decided. But the second argument was, well, it was really outside of work because the sexual harassment occurred outside of the party.
So when you say outside, you mean that they have the first session,
yeah,
which is work related,
yeah,
but then the guy just went upstairs and to have a separate, extended.
And I think
drink.
that the foolishness of that is, and that's why I say this is a poor decision, is any application of Rose and Telstra would have said it would be very difficult for him to come back to work the following day with an HR manager he just sexually harassed.
Yeah.
Particularly when their role is in supervision of labour.
Yeah.
Around the behaviour and conduct of people. That wasn't considered and wasn't a well-argued case. But it shows you that in these sort of cases, the legislation is designed to protect people. He gets away with it, not terminated. If she had brought a sexual harassment claim, she would have been successful, because this is legislation that is designed to protect employees. I threw Keenan up because I wanted to show you the risk of condonation. So if we go into Pluska, that's the next case. These are older cases we're just talking about. So Pluska's a case of a girl a woman who drank so much when they went out to a work function that she fell on the floor and vomited in one of the restaurants near the Opera House, and they terminated her employment. So it wasn't about it being unsafe to come to work, but when you look at the Rose and Telstra argument, is it inconsistent with the nature of employment? No, it's not. If you take people out to restaurants and you allow them to drink, you can't say it's inconsistent with the nature of employment. Does it damage the reputation of the organisation? Well, Sydney Opera House, small organisation, nobody knows who they are unless you're wearing team colours. No. Is it inconsistent with your capacity to work with people in your contract of employment? Well, they're going to laugh about you, but no, it's not. Okay, so it doesn't meet the Rose and Telstra test. So remember what Qiuyi and I are talking about. There's two arguments here. What happens outside of work, Rose and Telstra, doesn't lead to disciplinary action. Two, when what you did outside of work affects your safety at work, does it create a risk of safety in breach of lawful and reasonable direction? Different question. And with that in mind, I think we'll probably just go on to I think this is probably our last case that we actually talk about on it. Which is Lewis' case in Inco Ships. I'm sorry we're doing a lot of case law today, but part of that is it's very hard to explain what this risk is unless I take you through a series of cases which show the parameters of where this law sits. This is a much clearer case. In Lewis' case, he was working on a boat. He had to come off the site. He went out and had a whole lot of drinks. He knew that the policy was he was not allowed to attend that work site where he was staying affected by alcohol. Well, he was substantially affected by alcohol, and he actually gave the security guards a bit of a hard time as he came back on, and his employment was terminated. Now, what did he know? He had a lawful and reasonable direction about his level of sobriety. He was returning to a workplace which was an inherently dangerous workplace. He was directed to stop and given a lawful and reasonable direction not to do it, and he forced his way through.
Yeah.
So this is the classic example of when everything is lined up and is correct, and a person's breach of the behavioural rules leads to the inevitable conclusion of a serious misconduct. And the Commission in this case had no doubt at all in dealing with it and treating it like serious misconduct. Okay, so if we go back over the cases, what do we know? We know that Rose and Telstra cases, is it inconsistent with your contract of employment? Well, are you doing something which is, so you're a financial broker and you went and stole $200,000. I think that's inconsistent with your contract of employment.
Yeah.
Does it damage the reputation or business of the organisation? That's pretty straightforward. Does it interfere in your capacity to actually fulfil your contract? If Qiuyi and I go out and I bully him after drinking to the stage that he's not safe to come to work, well, that's Hunt and Camellia Holmes thing. Yeah, well, at that stage, my behaviour is inconsistent with my contract of employment because I can't actually come back and Qiuyi be safe in my presence. Okay,
Yeah.
So that's the Rose and Telstra out of work serious misconduct. But the big issue today is what are the rules and directions we have around people returning to work? That's the big question.
Yeah.
And them being safe. So proper policies, proper education, proper directions in place, and you can actually control your environment, and particularly in blue collar, heavy risk environments, testing.
Yeah.
All right, I think it's time for the case study, Qiuyi.
Yeah, case study.
You get a chance to speak now.
Yeah, got a chance to.
Here you go, mate. Off to you.
Okay, I'm gonna rate it. Sorry, that's it. Mike was tired. He worked as a maintenance fitter for Go Strong.
He gets it wrong later. That's all right.
Yeah, things will go wrong. That's it. A tire manufacturer. The maintenance group were the hard living group, all men aged between 35 and 50, all drinkers and all tired of the obligations around preventive maintenance. They love building and commission things.
So this is very common in maintenance, by the way. The maintenance guys hate doing preventive maintenance.
Yeah.
They love commissioning new things.
Can you talk about a little bit? Can you just tell us a little bit about preventive maintenance?
So preventive maintenance is the work you do to make sure a machine continues to operate.
Yeah.
That's what it does. So it's like putting oil in your car. It's like blowing your tires up. Okay.
Right. Sure. On Friday night, they went out together for drinks after work at the Harp and Happy Bar. All of them will complain about weekend preventive maintenance starting in 2 weeks' time. They drank until after 12 a.m., consuming around 18 full-strength beers in the standard glasses. The supervisor put some of the drinks on his card. GS knew about the ritual and supported the social gatherings. At 4 p.m., Mike
4 a.m.
4 a.m., Mike got called in for a machine breakdown. Everyone knew he was on call. He attended the site, and the night shift supervisor checked on him and asked if he was okay. He smelled of alcohol and was unsteady on his feet, but Mike said that he was fine. Mike went to the broken machine and had a crane contractor remove the motor. No risk assessment was undertaken by the contractor or Mike. As the contractor reversed with the motor hovering 2 meters above the ground, his crane struck an employee who had come to assist Mike. The employee subsequently died.
All right, so we've got some questions here. Would it be safe to dismiss Mike for being intoxicated at work and failing to do the risk assessment? All right, well, we don't have any policy and procedure we know about here. I think that you'd be on reasonably safe ground to dismiss Mike, simply because no court would defend him. Okay, more not only being affected by alcohol, but his role as managing that particular site at that particular area where they were doing it. It was his job. He didn't do a risk assessment. He had to do a risk assessment, and there was obviously a high risk. So the answer is yes. The only question you have in safety law, of course, is when you dismiss Mike, you're effectively pleading guilty to a breach.
Yep.
So you need some advice around actually how you do that, because the regulator would come in and the dismissal of Mike would be per se evidence of breach. Okay, different discussion. Has the contractor any risks under safety law? Well, yes, the contractor has massive risk because they are the owner operator of the crane, and it is their responsibility as a matter of law to coordinate the safety risk with the person present at site and to carry out the appropriate risk assessment and introduce the controls necessary for the safe use of the crane. So contractors here risk reckless endangerment type of risk. Has Mike any risks under safety law? Yeah, so let's start off. Mike has, remember Page case, he has some risk for personal liability. But unfortunately in Mike's case, the personal liability, which in Victoria is section 25, is not where this is going to end. He is drunk. He is affected by alcohol. He did everything that was wrong, which means he knew what he was doing carried a risk of serious injury or death to somebody in the workplace, and he was careless. He was indifferent to that risk. That's reckless endangerment.
Yeah.
Now, he's only an employer, so it can't be industrial manslaughter, but yes, he would be close to going to jail. He's at lots and lots of risk.
Yeah.
Does GS have any risks under safety law? Well, remembering that in safety law, liability is derivative. If Mike did it and Mike was permitted on site, then we know the company's already liable in reckless endangerment. And I think the company could go further because of their complete failure to manage alcohol and their support of alcohol. You may have Mike with reckless endangerment, the company with industrial manslaughter.
Right, sure.
Okay. I think we've got one or two other questions. We do. If Mike asked the supervisor to call OHS to get help and no one came, does that change Mike's legal risk profile? And the answer is a little bit. A little bit. What he should have said at that stage when he couldn't get them is to say, well, look, I can't do anything until you get them. So it may have mitigated against reckless endangerment, but whatever happened, he would be prosecuted. As the directors were aware of the drinking culture and drinks on a Friday night, are they exposed under safety law? And would it change anything if the CEO came in and saw Mike, raised concerns with him about his state of intoxication and let him continue to work? I want to conflate those two questions because the answer is the way it sits at the moment, I think the company would be charged with industrial manslaughter, but certainly reckless endangerment. The issue then is liability of the executive officers or the people who are liable. If it is evidence that the officer of the business or any officer of the business was aware and condoned the drinking of people in the manner in which they do, there is a strong chance that they would be linked into that liability. It might be in Victoria, because it's actual knowledge, a section 144 breach or a due diligence breach that sits elsewhere, but the regulator would be pursuing them. Okay, they would be interested, and actually coming on site and noticing the risk and letting them to work means you have a hand in the disaster. So one of the things to remember is with reckless endangerment or industrial manslaughter, the fact that you do something is not exculpatory.
Right.
Okay.
Yeah.
What it is it demonstrates your knowledge and failure to actually do what you ought to have done. So in some ways, the CEO's actions have brought him or her into the game, into liability, into a much more serious one. So, guys, that's it tonight. Poor Qiuyi. I'll never do this to him again. Just grab him off the street. But thank you very much for coming in, mate. You did a great job.
Thank you.
Kim, please get better. And Nina, please come home. Thumbs up. We'll see you later. Cheers.
Bye.